Companies Act, Section 421, Appeals from Orders of the National Company Law Tribunal, NCLT. Section 421 of the Companies Act, 2013 provides the statutory right for any person who is dissatisfied or adversely affected by an order of the National Company Law Tribunal, NCLT, to challenge that decision before the appellate authority, the National Company Law Appellate Tribunal, NCLAT. This section outlines who can appeal, the time limits for appeal, the procedural requirements, and the powers of the appellate tribunal when deciding such appeals. The inclusion of this appeal mechanism is essential for ensuring justice, fairness, and the ability to correct potential errors made by the tribunal. 1. Right to appeal before NCLAT. Any person who feels aggrieved by an order of the NCLT may file an appeal before the NCLAT. This includes companies, creditors, members or shareholders, officers of the company, insolvency professionals, or any party affected. Thus, the remedy is broadly available to ensure fairness and accountability in tribunal proceedings. 2. No appeal in consent orders. No appeal can be filed against an order that has been passed with the consent of both parties involved in the dispute. This is because when both sides mutually agree to a decision, the appellate tribunal is not expected to interfere with the settlement voluntarily reached between them. 3. Time limit and conditions for filing an appeal. Within 45 days from the date the copy of the NCLT order is made available to the aggrieved person, in the prescribed format and accompanied by the prescribed fee. This ensures procedural discipline and prevents unnecessary delays in legal proceedings. However, recognizing that genuine difficulties may arise, the law also allows for a limited extension. The NCLAT may accept the appeal even after 45 days, but only within a maximum further period of 45 days, and the appellant must show sufficient cause for the delay. This ensures that justice is not denied due to minor or unavoidable lapses while still maintaining predictable deadlines. 4. Powers of the appellate tribunal when deciding appeals. Give all parties involved a reasonable opportunity to be heard. Carefully consider the submissions and legal arguments. After hearing the appeal, NCLAT may confirm the NCLT order, or modify the order if changes are justified in law, or set aside the order entirely if found to be incorrect, unlawful, or unjust. This grants broad authority to the appellate tribunal to ensure that justice is truly served. 5. Communication of appellate orders. After deciding the appeal, the NCLAT must send a copy of its order to the original tribunal and to all parties involved. This ensures official communication of the decision, awareness of appellate directions or modifications, compliance and further action, if necessary. Importance and impact of Section 421. It protects the legal rights of all stakeholders in corporate matters. It acts as a check on the correctness of NCLT decisions. It strengthens accountability and transparency in corporate adjudication. It ensures that errors or injustices can be corrected through a structured appellate review. It enhances confidence of investors, creditors, and the business community in the dispute resolution framework. By establishing a clear appeal process, Section 421 upholds the principles of natural justice and reinforces the rule of law within India's corporate governance system. For more details, contact us.